Good afternoon and welcome to this March. It's not March yet. It's February. Welcome to this February edition of In the Boardroom. My name is Andy Phillips. I'm with Attolles Law, and we are privileged to serve as general counsel to the Counties Association. I think, as everybody's aware, every month we get together on the last Wednesday of the month and have a discussion about topics of interest within county government from a legal perspective. And this month's edition is on the County Board Organizational Meeting, which is right around the corner. Within the next 2 months, we're going to have counties all over the state organizing to transact business for the next 2-year term. A couple of housekeeping items before we get going with the actual presentation. If you have a question during the presentation, hit the Q&A button or the chat button, and I will do my level best to get to your questions as we proceed. I say level best because we do not have Sarah Diedrich with us this week, so we do not have the ability to go back and forth between her and I to identify some of those questions or issues. So keep that in mind as we're going through the questions, that there may be a slight delay as I work through those. Second, this webinar is being recorded and it will be posted to the WCA's website, wicounties.org, as soon as available. Based on experience, that will probably be later this afternoon or tomorrow morning when that is made available. As well, the slide deck from the presentation will be made available at wicounties.org as well. So without further ado, let's begin our discussion on the County Board organizational meeting. And when we talk about the organization, well, let's first give an overview of what we're going to talk about. We're going to talk about the organizational meeting, but we're also going to talk about the process of conducting elections. And then we're going to hit a topic that I think is near and dear to my heart, and I think is near and dear to a lot of your hearts, and that is, how do we create the foundation for success in the next 2 years at the organizational meeting? Because remember, this is the very first opportunity where we have new supervisors that are being seated, and this is their first impression. So what impression are we going to give them about the way that our county does business? So this is, again, something from my perspective and the perspective that I've seen around the state on very practical terms, not legal terms, but practical terms. How do we create that foundation for success? So the organizational meeting itself. In the statutes, we have reference to an organizational meeting. 59.11 sub 1 sub C says that, except in counties with a population of 750,000 or more, that's Milwaukee County, and they have their own rules about the organizational meeting, all the counties shall meet on the third Tuesday of each April to organize and transact business. So if you look at the language of 59.11.1C, there's specific reference to an organizational meeting that happens every April, each April in an odd numbered year, and each April in an even numbered year. So why is it that we have in our minds as counties this organizational meeting that only occurs in even numbered years on the third Tuesday in April, right after the elections? Well, it is for this important reason. You got to remember when these statutes were written. If you look at 59.11 of the statutes, it refers to an annual meeting and an organizational meeting. Two meetings. I think back in time, there was a period of time when several county boards around the state only met twice per year because that's all they were required to meet. And so the statutes were not updated as counties grew in terms of their sophistication, in terms of the issues that they need to present and the issues they need to deal with. But we have counties that are now meeting monthly and many counties that meet more than once a month. And so the statutes did not keep up with the way that county practice has evolved. So when we talk about the organizational meeting, don't think about it as the meeting where the elections occur. All right. Think about it as the required meeting in the spring that the legislature established many, well over 100 years ago. All right. We'll get to the statute dealing with elections in a moment, but I just wanted to point this out to the extent anybody went to go look at 59.11.1C and say, wait a second, we're supposed to have an organizational meeting on the third Tuesday of April every year. You do. That's what the statute's called, the organizational meeting, but the way we think of an organizational meeting is different than what this statute involves. So statutorily, what are we required to do at the organizational meeting? Well, it simply says in the statute, the board may transact any business permitted at the annual meeting, which means it's all the business that a county board can take up under Chapter 59 and the authority of other Wisconsin statutes. And we can appoint county commissions and committees. Now, the word may is used in the statute. Whenever we have the word may appearing in statute, that means it's discretionary. We're not required to do certain things in 59.11(1)(c). All right. It also says that the meeting can be adjourned in the same manner as the annual meeting. And what used to happen, frankly, is that there would be an organizational meeting, an adjournment of that meeting. You may meet in the interim between April and November when the annual meeting occurs, and then any meeting occurring between those dates is considered an adjourned session of the annual meeting or an adjourned session of the organizational meeting. So again, the statutes aren't keeping up with the way that counties actually operate and the way that county boards actually govern. So I don't want you to read too much into those statutes. Because what's important here too, to the extent that we have any sort of legal analysis going on with these statutes, is you have to remember 59.03 of the statutes. 59.03 of the statutes and 59.06 of the statutes give the counties the authority to conduct business the way that they deem fit, so long as it isn't contrary to an issue of statewide concern spoken on by the legislature. So unless we have a state law telling us and mandating us that we do things a certain way, we have the freedom to organize as we see fit. What we do at these meetings and the way that we adjust our calendar, how often we meet, the terms of those meetings, things like that, those are all matters of local concern. And so we have the ability under administrative home rule authority to conduct ourselves as counties the way that we see fit. So the other point I want to make on this is that I just got done with a big discussion about administrative home rule authority, our ability as counties to govern ourselves the way that we see fit. Where is it that all of the rules of procedure, all of the expectations, where are all of these things contained? That's within the county board rules. There's no statute on this. There's no guidebook that the state publishes. It is up to us to establish our own board rules. Organizational meeting ought to be part of those board rules. If you have questions about board rules, if you're interested in learning more, we have done sessions in the boardroom on board rules. In fact, we did one last month. So if you go to wicounties.org, you can look at past event materials and find a robust discussion on board rules. And you will see in there, in the template board rules that we produced with WCA, you will see that the organizational meeting is addressed. All right. So again, the organizational meeting from a statutory perspective, don't read too much into the words because we do things a little bit differently and the statutes have frankly not evolved with the evolution of county government. Now, we always elect officers at the organizational meeting. Our organizational meeting, the way we think of an organizational meeting, third Tuesday in April in even numbered years. 59.12 is the statute that deals with election of officers, and it says that at the first meeting after each regular election, we elect a board chair. At the time we elect a board chair, we elect a vice chair. So that's right in 59.12, sub 1, sub 2. Now, when we look at this statute and compare it to 59.11, recall that 59.11 used the word may. And I said that means we have discretion to determine what it is that we want to accomplish at an organizational meeting. 59.12 uses the word shall. We don't have discretion whenever the word shall is used. This is a dictate, a mandate from the state legislature to us as counties saying that we have to elect a board chair at the very first meeting that we hold after the election of new supervisors. And we know that the first meeting we hold is on the third Tuesday of April because we know that we have the organizational meeting on the third Tuesday of April in even numbered years. Contained within 59.12 is a listing of the duties of the chair and the vice chair as well. This is another situation where we turn to our board rules to fill in a lot of blanks. Because if you look at the duties of the chair and the vice chair in 59.12, these are somewhat ambiguous and it's somewhat short in terms of that list of duties. There may be a whole lot of other things that we expect our board chair or our board vice chair to do. So where is it that we will find those other quote unquote things? That's within our board rules. Again, go back to wicounties.org, past event materials, look at the board rules templates. that is contained within those materials, and you will see where that template of the board rules addresses chair and vice chair responsibilities. Committees. We also know that in many, many circumstances, county boards, when they gather on that third Tuesday in April, they meet, they also appoint committees. And there are a variety of different ways that committees are comprised or appointed, meaning that it could go through a committee, it could be a board chair appointment, could be a board chair appointment with county board confirmation, could be a county board appointment to the committees. The way counties do it varies all across the state. Hint, address it in your board rules because we want to have a clear process on how committees are comprised. But 59.13 sub 1 says that we can, by resolution and designated the purpose and the duties, authorize the chairperson to appoint committees. The date that is in there gives us some flexibility. Doesn't say we have to do it by the organizational meeting. We just have to do it before June 1 in any year. So we have the flexibility to create committees. And I would say under 5903, 5906, and 5952 home rule, or excuse me, 59.51, that we have the authority in our board rules to dictate when it is that we are going to create committees, how it is that we amend a committee's responsibilities, how we create ad hoc committees, and so on. So again, let's make sure in our board rules, we establish the process for creation of committees, and that we also establish the process for how people get on committees, all right? So you'll see in the bullets under there that those bullets are not part of the statute, obviously, but I asked the question, what is the committee appointment process? What works in your county? What is the timing associated with committee work? In other words, is this going to be done at the organizational meeting, third Tuesday in April, or are we going to have another meeting in May where we have a period of time between that organizational meeting and the May meeting in which to have a recommendation brought before the board as to committee composition? And then the question, how are executive or administrator appointments handled? Because remember, for those counties that have an executive or an administrator, 59.17 and 59.18 of the statute says that the executive or administrator is responsible for appointments to boards and commissions subject to board confirmation. So what is the process for the executive or administrator to submit names for board confirmation on those appointments? Again, process that we can establish within our board rules. We want a good agenda for our organizational meeting. I always like to say that if we don't have an agenda for a meeting, it's not really a meeting because we want to know what the purpose of that meeting is going to be. And an agenda gives us the boundaries or an outline of what that purpose is. So remember that under the law, we can transact whatever business we want to transact at that organizational meeting. Now, there may be items of urgent interest that we need to take up at the organizational meeting. I will tell you, though, that if we treat the organizational meeting as a regular business meeting, it may be a little bit of a mistake. And the reason I say that is that we are inevitably going to have new board supervisors taking their seat, and we would be asking them to vote on an issue about which they know very little. So I think it's a bit unfair to expect those new supervisors to come in and immediately get launched into a business meeting without some sort of orientation. All right. So if we look at the agenda, and this is not anything that's in statute, it's not anything that's required by Robert's rules. This is purely my idea on what the agenda could look like based upon my work with WCA and counties all around the state where we've attended and participated in organizational meetings. If we look at this bullet list, though, we've got a call to order, roll call, administration of the oath of office. That's really important. The oath of office is a really important step. The written oath that is signed by the new board supervisor becomes the official record of receiving an oath of office. But the ceremonial stand up, raise your right hand, repeat after me is a very important concept. It's a tradition in most counties that I've been in. And I think it is a really cool opportunity for the new supervisors and frankly, everybody, because everybody's administered the oath, to participate in this process. It underscores the importance of the work that that county board supervisor and the board itself is going to undertake over the next 2 years. After oath of office, we have election of officers. We want to list what officers we're electing on the agenda. There are many counties who have a second vice chair. There are some counties that have a sergeant at arms. Whatever their, remember, board and vice chair, by statute, we have to have those two. But again, if we have others, we want to make sure that we elect those officers as well. And so on the agenda, we have election of officers, and then we proceed in order according to our agenda on which officers we're going to elect. Typically, it's going to be, I think in all circumstances, it will be chair, vice chair, and then anybody else. Committee appointments. We had the discussion earlier about whether committee appointments happen at the organizational meeting or at some time thereafter. Either one is just fine, but let's put on the agenda exactly what that process is. Education. And this is where it's really, really important in my mind to have a significant amount of time set aside at the organizational meeting or in close proximity thereto related to letting the new supervisors know exactly what the expectations are to be a board member within the county. And I just said new supervisors, but frankly, that applies to every supervisor. I think it's always good to have that discussion every 2 years to, again, set the table for success going forward over the next 2 years. So what does education look like? What can it be? WCA, Sarah Diedrich, we've participated in education at organizational meetings for the past 20 years. We've been having discussions with county boards at that organizational meeting. Typically, our discussion centers on roles and responsibilities within county government, but it's an opportunity to have other education opportunities as well. Open meetings law, public records law, ethics and conflicts of interest. Those are just some examples of things we've seen throughout the year. I think it's really important to have a conversation with corporation counsel about what type of education and training from a legal perspective that the county is going to provide through corporation counsel and what it is that we want WCA to provide. WCA brings a bit more of a statewide focus to the entire conversation. So sometimes it's better that WCA address a topic, whereas in certain counties, I know that corporation counsel wants to address certain things and emphasize certain points, and by all means, corporation counsel ought to do that. Beyond legal training, let's talk about what other information is necessary to be conveyed to the board in terms of, again, setting that foundation for success. I think it's an opportunity to have a discussion with your constitutional officers and your department heads about the really important work that they do. Now, does that mean we have to give each constitutional officer and each department head an hour to talk about what they do? No, not necessarily. But I do think it's an opportunity to introduce constitutional officer and department head to the board and give a brief overview of the workings within their office or department. So it's that type of education opportunity that I think exists at the organizational meeting as well. Finally, there may be other specific items, some legal, some non-legal, that you want to get into at the organizational meeting. You may want to have a refresher session on your board rules, for example. Great, do that. I say all of this to say it's up to you to determine what education or orientation is going to happen at that organizational meeting. Regardless, I am of the firm opinion that there ought to be some orientation or education, that we ought to limit the actual business that proceeds at the organizational meeting. That said, it's entirely up to you on what that agenda looks like. Just know that WCA, me, and the team at Attolles, we're happy to help whatever county needs assistance as it relates to the organizational meeting. Reach out and we're happy to walk through ideas. That said, I will tell you that we have a lot of calls from a lot of different counties asking for participation in an organizational meeting, and we can only be in one place at one time. So if we say, can we postpone to the next meeting, that's why, because we get awfully busy in even numbered years during April and May. So just be aware of that. The next item is business. We can take up whatever business we need to take up at the organizational meeting. It can be treated as a regular county board meeting. And that's fine if you want to do that. Again, though, I would caution that if we have items of business that are rather heavy, if you will, going to require some deliberation, contentious, it's going to generate a lot of debate, let's consider having either a special county board meeting after the organizational meeting, like a week after, or postponing consideration of that item of business until our May meeting, just so the new supervisors can get oriented with what they need to do and expectations are established about how we do business within our counties. And then we have adjournment. So again, You have a lot of flexibility in preparing this agenda. Just make sure you have an agenda out there so that we have an understanding of what it is that we want to accomplish at the organizational meeting. So we've got an agenda out there. We've established protocols for how we're going to conduct training. We've established the expectations. What do we do when it comes to the actual meeting day? Calling the meeting to order and conducting elections. I'm going to focus on that because we know the one thing that we definitely have to do at our organizational meeting is elect a chair and a vice chair and any other officers of the county board. So I'm going to focus on this whole concept of getting us from the point of calling the meeting to order to conducting those elections. First question I often get asked, who chairs that organizational meeting? We have a board chair from the previous session that may be on the board for another session. Is it appropriate for that board chair to assume the seat until we have an election for board chair? You can do that. That's fine under both Robert's rules and Chapter 59. You can do that. I would highly, highly recommend you don't do that, though, if that board chair from the previous session is going to run for board chair again. The reason being is that we don't want to provide any particular candidate for board chair favoritism or a leg up in that voting process if we can avoid it. So we could have the current chair that meeting. That's fine. We could have a former chair assume that seat. If that former chair is no longer on the county board, you don't have to be a board member to be chair pro tem or temporary chair of the organizational meeting. We could have the vice chair or second vice chair chair that meeting. The county clerk, corporation counsel, someone trusted. In other words, the list is rather long of the people that are qualified and capable of chairing that organizational meeting. I will tell you, though, again, that we want somebody who's disinterested in the upcoming election for officer positions within the county. We also want somebody who's trusted, that has the faith, that has the ability to organize the board and maintain order during that organizational meeting. I can tell you that I've seen corporation counsel chair on a temporary basis the organizational meeting. They've done an awesome job. I've had the pleasure of chairing the organizational meeting in several counties. I've thoroughly enjoyed that because I get to sit in the big chair and wear the big hat with the big gavel. It's awesome and it's a lot of fun. But ultimately, it's up to you as to who you want to chair that meeting. Figure out who that needs to be well in advance of the organizational meeting so we don't run into any problems when it comes time to gavel that meeting to order. Nominations. So we have a call to order. We have the agenda. We have the Pledge of Allegiance. First item of business, we get into nominations. This is where we get into elections for chair, vice chair, and other offices. So when we're calling for nominations, we simply get to say the floor is open for nominations for the position of chair. Somebody who wants to nominate somebody else for a particular office doesn't have to be recognized by the chair in order to make the nomination. That's in Robert's Rules of Order. Anybody that's on the county board can nominate another person for a particular office or position, and you can even nominate yourself for a particular office position. There's no second required, but oftentimes you will hear a second on nominations as an indication of support for a particular candidate. Seconding speeches under Robert's rules are allowed. So if the seconder wants to make a comment about the qualifications of a particular nominee, that seconder can certainly have that speech, can make that speech. Once the nomination comes in, it's shouted from the group. The chair should restate the nominee and it places their name before the body and for purposes of the upcoming vote. Once we have the nominations that are in, I've seen different counties do it different ways, but in many counties, they have an opportunity for the nominees to address the body and provide their impassioned plea as to why they ought to be board chair, board vice chair, or another officer of the county board. Now, again, I think if you look at Robert's rules, there's a lot of discretion within Robert's rules as to how this process of nomination and voting plays out. I would like to see the board rules establish the process for nomination, the ability to speak as a candidate or as somebody in support of a particular candidate. If we have that process in our board rules, obviously those board rules are out there for consumption well before the organizational meeting. We can establish expectations so that we have a very smooth running organizational meeting. Now, again, once the nominations are closed, the chair can close nominations. Nominations aren't necessary in order to vote for a candidate. I want everybody to know that even though Bob and Larry may have been nominated for board chair, that doesn't mean that Susie can't be on the ballot, so to speak, to be board chair. Just nominations are a way of theoretically narrowing the field so everybody understands who it is that has support from the board perspective in order to assume a particular office. A motion to close nominations is not necessary. It's not required. Oftentimes, though, we see motion to close the nominations and cast a unanimous ballot in favor of candidate A. For example, that is always in order when we have candidate A being the only nominee for a particular office or position. So it would be appropriate, if there are no other nominations, for the chair to request that there be a motion to close nominations and cast a unanimous ballot in favor of candidate A. Now, a motion to close nominations is not in order until a reasonable time has been provided to the body to make their nominations. All right. So if somebody wants to nominate others, then we have the ability to say your motion to close nominations is out of order. That leads me to bullet point number 5 on this, which is a misconception that's out there that I've seen repeated in every county. And that is, I see chairs asking for any other nominations 3 times before nominations are closed. I don't know where that came from. I think it's just historically the way things have been done for quite some time, which is fine, but you're not going to find it anywhere in Robert's rules. You're not going to find it anywhere within Wisconsin state statutes. And so this whole tradition of asking 3 times, are there any more nominations? Are there any more nominations? You don't have to do it 3 times. That said, because of the other principle that says that a motion to close nominations is not in order until a reasonable time has been given, the 3 questions being asked, that may relate to that whole concept of providing a reasonable time. Again, however you do things in your county is just fine. A motion to close nominations requires a 2/3 vote. It's not debatable. The chair can also close nominations if it's apparent that there's no other nomination that's coming from the body. As I stated earlier, the board rules can provide a process for nomination and for those seeking a position to actually advocate for their particular candidacy. I would love to see that in board rules because then we have order. We have the ability to say, now is when we close nominations. We're going to ask the candidates to come up and address the body for no more than 5 minutes. Are we going to allow them to hand out materials? Are we going to allow them to use demonstrative exhibits if they want to put up a chart or something like that? We define that entire process within our board rules. I get this question every couple of years, typically during the spring of an even numbered year. What happens if we have somebody that's out there in the second week of April calling all of the board supervisors and asking them for their support as it relates to their seeking election as board chair? Do the walking quorum principles apply? The short answer is yes, that all of the same open meetings law concerns that apply in normal business situations apply in officer elections. There's no carve out, there's no exception. But I will tell you this, that I don't see any issue with a particular supervisor, either one-sided communication, I'm asking for your support next Tuesday because I'm running for board chair, end of discussion. That's fine. I see no issue with somebody distributing one-way written material seeking support. Again, if your board rules prohibit that distribution, that would be a different story. But if your board rules allow it, I see no problem with the one-way communication. But when we get into problems under the open meetings law, and frankly, I hope that we never have to address this, but if where we get into problems under the open meetings law is where we start building consensus surrounding one particular candidate or another, that's where we have open meetings law concerns. Again, I personally think that it's kind of silly to have the open meetings law apply to these officer elections because we're talking about the internal politics associated with the board having nothing to do with public business. But again, The open meetings law doesn't have a carve out. And again, I think reasonable minds can disagree as to whether that is an item that should be subject to the walking forum rules under the open meetings law. So just be aware of that. If you have questions about the open meetings law and its application to your board rules or the process that you have for nominations and election, please talk to your corporation counsel. And if your corporation counsel has questions, we're happy, me, WCA, to be a resource for your corporation counsel as well. As I indicated earlier, I like to see a process within the board rules where the candidates have an opportunity to address the board. They can say a few words about why it is that they want to be board chair, vice chair, or other officer. I ask the question, can they distribute literature? Can they make a PowerPoint presentation, for example? Again, let's address those within the board rules. As I indicated earlier, if there's only one candidate, then the chair can accept a motion to close nominations and cast a unanimous ballot in favor of that candidate. Officer elections are the only time where we as county boards have the ability to use secret ballot method of voting. Otherwise, everything has to be done in the open in terms of the voting, all right? The statute 19.88 sub 1 says specifically that the only time that we can use a secret ballot is to elect the officers of the county board. So that raises the question of how does secret ballot voting occur? We like to see a process where we have ballot clerks that are appointed by the chair of the board. All right, so the board chair, even if it's the temporary chair, appoints ballot clerks who are going to have ballots prepared, and those ballots will be blank sheets of paper. We want them to be all roughly equal size. They distribute them to the board. The supervisors vote, and the ballot clerks gather those ballots and then tally the results. We want those ballot clerks to be dependable persons. Typically, it's going to be a county clerk and somebody else designated by the board chair or the clerk to assist in that process. But again, we want that position to have the confidence in the membership that they're going to tally the vote appropriately and that they're going to report the results appropriately. On the elections, remember that we continue to vote until a majority is reached, a majority of the board. It's not a plurality when if we've got three candidates and one candidate receives a plurality of the votes, that candidate doesn't win. We have to have a majority of the board agree as to who the board chair and board vice chair are going to be. All right, so we continue voting until we have that resolved. I've heard in counties that this process can take hours to unfold. I've heard of up to 40 ballots where this occurs. Hopefully that doesn't occur third Tuesday in April for you all. But again, it just speaks to this concept that we need to have a majority of the board agree as to the officer positions. Now, I'm going to talk a little bit about Robert's rules, not necessarily your practice, not necessarily your rules, but Robert's rules. Robert's rule says we never remove the lowest vote getter. All right. We'll talk about that in a moment. So when we're on successive ballots, ballot one, we have candidate A receive 7 votes, candidate B receive 6 votes, candidate C receive 4 votes. So we have plurality, but we don't have majority. Then we don't remove candidate C. That's just not going to happen. And I'll tell you why in just a moment. But I want to say very clearly that Robert's rules does not say that we remove that lowest vote getter. When we're getting into this process of voting, and if we see ourselves going ballot after ballot after ballot and not a lot of movement on result, we may want to take a recess, give ourselves a little bit of time to take a breath, gather our thoughts, give the candidates perhaps an opportunity to address the board again, to talk about their qualifications or other issues. But it's an opportunity for us to reset the table, if you will. Then once we have a victor in the board chair election, then that victor assumes the board chair seat for the balance of the meeting and becomes the chair. So I talked earlier about how we don't get rid of the lowest vote getter, the lowest total vote getter. We don't do that because the lowest vote getter might be a compromise candidate between the factions that are supporting candidate A and candidate B. And that's happened. I've seen it happen in counties where they are not moving forward with candidate A or candidate B, and it becomes very clear that there is no way either of those candidates are going to hit the majority threshold required. So then people coalesce around a compromise candidate. Oftentimes it might be candidate C. So again, we have to be very careful whenever, even in our board rules. Now, I would highly recommend our board rules not say this either. We don't want to eliminate that lowest total vote getter because there's good reason that they stay on the ballot. Again, we just want to have that process, whatever it may be, contained within our board rules. Now I'm going to spend a little bit of time talking about the opportunity to create a foundation for success at our organizational meeting. It's a really daunting task to assume that seat as board supervisor for the first time. I want everybody to imagine that they're a first-term supervisor. You've just taken your oath of office, all right? So the pomp and circumstance and the ceremony is awesome, and you feel incredibly empowered, and you can't wait to get to the important work within your county over the next 2 years. But the next item on the agenda is a business item, and it says that the Human Services Department is asking for a $250,000 transfer from contingency to pay for an out-of-county placement for a person under their care. What do? You know nothing about human services. You know nothing about what an out-of-county placement means. You know nothing about what this entire issue is all about. Why do we have to transfer money out of contingency? Isn't this something that we would normally budget? How incredibly intimidating. Well, again, getting back to a point that I've discussed earlier, let's use the organizational meeting as an opportunity to orient that new supervisor as to the expectations for the issues that that supervisor is going to deal with over the next 2 years. Let's not ask them to do the actual business just yet. We'll get to that in soon enough. We'll get to that in May. But for now, let's make sure that we have them appropriately trained and oriented to their role and job as a county board supervisor. Now, I talk about how the organization meeting is an opportunity and a challenge as it relates to education. The opportunity is there for us to establish that foundation of success by giving them the tools that they're going to need over the next 2 years to be good board members. But the challenge is there's no way within the time allotted for us to adequately educate the board. So I say that counties ought to be thoughtful about what it is that they provide to new supervisors, and for that matter, the entire board at the organizational meeting in terms of education and training. But then let's also think about the ongoing opportunity that we have as county boards to educate and train throughout the year. There is nothing in statute that says we can't have a discussion, training, education at any other meeting of the county board throughout the year. I've talked about this concept before. Many of you may have heard about it, is that I would love to see constitutional officers each be given a half hour at a particular interval throughout the year at a county board meeting to discuss what's going on within their office. What are the issues that they're confronting? What are some of the concerns, especially when it gets to budget time? What type of resources are necessary for them to carry out their statutory mandated responsibilities? Same with department heads. Department heads have an awful lot of mandated responsibilities. When's the last time as a board we got together with a department and had a discussion about what it is that they do and how they do it and what resources they need to carry out that function? It's an opportunity for the department head or constitutional officer to share information, but it's also an opportunity for the county board to ask questions. And the county board members should ask questions of that constitutional officer and that department head. Now, that type of robust discussion is not going to occur at the organizational meeting. We simply don't have the time for it. We have time for an overview. I talked about the overview, and that's fine. But then let's think about throughout the year if we have opportunity to invite that constitutional officer or department head in for a deeper discussion about what it is they do and how they do it. We want to establish our expectations long before the organizational meeting. If we get to the organizational meeting and wait until then to establish expectations, in my mind, I think we failed a bit. We failed a bit because we have ample opportunity to establish those expectations so we can get to the organizational meeting and we can really talk about some deeper issues during the orientation period. So I asked this question: does your county have a job description for county board supervisor? Some do, many do not. I think it's worth having a discussion as to whether it's appropriate to have a job description in your county for county board supervisor. That job description can not only lay out the statutory qualifications to be a board supervisor, of which there are relatively few, but then it can also establish expectations for meeting attendance, expectations for preparation, and then expectations for relationship between board, department heads, administration, and so on. So if we have that in a written job description, it's right there in black and white before the organizational meeting ever happens, and there can be no question as to its legitimacy. It's there. So I would really encourage counties to take a look at this concept of establishing job descriptions for county board member. Does your county have a strategic plan? Again, many counties do, many counties do not. But have we provided that strategic plan to board members before that organizational meeting? That strategic plan theoretically ought to give you the course for the next 1, 3, 5, 10 years on where your county needs to go. What the county board decided during the strategic planning process were the priorities for the county. So that strategic plan is an incredibly important document as it relates to orienting a new supervisor to the goals and aspirations, the strategic plan of the county. Along those lines, what I will also say, and it's not on here, is that we all have a budget. We adopt our budget in November. We levy a tax to support that budget. And that budget is the primary driver of not only financial decisions, but policy decisions for the county throughout the coming year. Have we distributed that budget document to new supervisors and make sure that they understand its contents? Do we have an organizational chart showing the different departments and functions? And I understand the organizational chart can get awfully complicated, but even from a simplistic view, do we have something that we can give to our new supervisors that is going to orient them to the operations within county government? Do we have board rules? We should. And if we have board rules, have we distributed those board rules out to the new supervisors prior to that organizational meeting? Now, we have the 4 bullet points here, and I added a 5th with the county budget. When should we hand these documents out to the new board members? I happen to think that we hand those documents out when somebody takes out nomination papers to run for office. And I've gotten some pushback on that because I've had folks say, no, we don't want to overload people. We actually want to encourage people to run for office, and we want to keep them in suspense as to how difficult their job is going to be until they sit in a seat. Joking aside, I do think that at some point prior to the organizational meeting, it would be incredibly prudent for us to have a set of documents like this. It doesn't have to be this exact set. You decide what's important in your county, but have a set of documents that we distribute to new supervisors prior to that organizational meeting. All right. So we have expectations that are set before the organizational meeting, and those, in my mind, lead into what I view would be a productive organizational meeting where we can get down to really important questions surrounding the way that it is we govern ourselves as a county board. So we've talked about, oops, I skipped ahead too far. My apologies here. Potential areas for education. I've touched on this a bit previously, but these are areas that we have seen addressed in the organizational meeting. I would hesitate to say all of these things ought to be addressed because I don't think adequate time can be set aside at the organizational meeting to really responsibly delve into a lot of the topics that we have here in this bullet list. But we have county board rules, roles and responsibilities within county government, parliamentary procedure, open meetings law, public records law, and then again, conversation from your department heads and your constitutional officers. Now, as it relates to presentations from department heads and constitutional officers, those are solely within your expertise as a county. There is nothing that the counties association can do to give you insight as to how a particular office or department within your county operates. So that's on you. As it relates to everything else, with a small exception for board rules, but roles and responsibilities, Parley Pro, open meetings law, public records law, ethics, conflicts of interest, those are all areas that I know WCA is really eager to help counties in. So if you find yourself in need of training and education resources, please reach out to WCA. And to the extent WCA doesn't have resources, I guarantee you we can put you in touch with UW Extension who has resources. So there are all sorts of opportunities out there to get training and education on particular topics. As long as we're talking about that, I know that there is opportunity for training and education right around the corner after the election in the spring, and that's the county officials workshops. Those happen all across the state at various times throughout the spring, where essentially the extension office, the counties association, and I believe the towns association might participate as well, invites officials in to speak to this concept of what it is you need to know as a county board supervisor. So be on the lookout for invitations to county officials workshops. Again, those are right around the corner. I've mentioned this before that there are several resources that you can rely upon to provide you with the education and training. We have internal experts from administration, department heads, corporation counsel, constitutional officers, and then we also have external experts as well. So feel free to lean on those various resources to assist you in this process of, again, creating the foundation for success at the organizational meeting. I can't stress this enough. I've said it before, I will say it again. If we have a really good organizational meeting, that sets a tone. And that tone is going to be what I would think to be a productive tone over the next 2 years. If we have a very chaotic organizational meeting with very little training and very little focus on the important work that we're about to undertake, then I think we have an opportunity for disagreement, discord, and chaos to interrupt what would otherwise be a smooth county board meeting process over the next 2 years. So I am about 15 minutes early in terms of the conclusion. That's not surprising. This is a topic I've addressed before. And so I wanted to make sure that we covered all of the material, but I'm going to open it up for questions now. So feel free to hit the Q&A button or the chat button, type your question, and I will get to it as quickly as I can. We have a question from Julie. How much should a county executive or county administrator be involved with the organizational meeting? In terms of the planning process, it's not a problem they have the executive or administrator involved, but really it ought to be a board-driven issue. And when I say that, I mean that we ought to have some understanding of what the organizational meeting looks like within our board rules. When it comes to the specific training and education that's going to take place, an executive or administrator has a really firm grasp on what's happening within our constitutional offices, what's happening with our department heads, any gaps that the administrative or the executive has seen in terms of education for the board that would assist over the next 2 years. And so I think they are involved extensively when it comes to the orientation, if you will, about how the county operates. But in terms of the actual organizational meeting itself, that's a county board meeting. And so the county board is responsible for establishing that agenda. And I would highly recommend that we address that within the context of our board rules. All right, other questions that we might have. I hope everybody noticed that I actually put a suit and tie on for this today because I wanted everybody to feel like I was super important today and able to get to these issues. That's how important I think this topic is. Other questions that we have here. Well, we've got a moment then. I am just going to talk about next month's in the boardroom. Next month's in the boardroom was inspired by a discussion I had with the Wisconsin Public Employer Labor Relations Association, WPELRA, at the end of January at their annual conference. There was an issue and questions that came up about the process in dealing with elected officials at the city or county level and how they are removed from office. And in my estimation, the misconceptions that are out there about removal of particular officers, whether they be county board members, constitutional officers, county executives, county administrators, and so on. And so I thought in March, it would be a good opportunity to have a discussion about Chapter 17 and what is required, because it is not a very simple process and it ought to be used quite sparingly. But then also talk about the relationship with constitutional officers and other elected officials within the county and how we can, again, create the foundation for success. So we're going to talk about that during the March in the boardroom. Frank asks a question here. Andy, you refer to board rules often. Assume these are the existing rules. Do they have to be reaffirmed each term? To me, it depends on whether they're codified. Are they an ordinance? I highly recommend that counties codify their board rules, put them in ordinance. That way they are a permanent feature of the county code. They continue in existence through any successive term of the county board. The question arises if they're adopted by resolution as to whether those board rules or that resolution expires at the end of the county board's current term. Now, I think you can make arguments both ways. I don't happen to think that they expire necessarily, but I would like to eliminate that doubt, if you will. That's why I want to see them codified. So I think it really depends upon whether your board rules have been codified, and if they've not been codified, how permanent were they intended to be when the resolution adopting those board rules was adopted? And that's where we want to look back. So there's no bright line answer about whether they have to be reaffirmed or not reaffirmed. It's more or less taking a look at the history of those board rules, and if we need to reaffirm, make sure that we do. Mark Liberta, he says, Andy, you said Robert's rule says we never remove the lowest vote getter. After that, you said Robert's rules doesn't say we don't remove the lowest vote getter. Those seem to be different things. Which is it? My apologies, Mark, if I was unclear on that. Roberts says we don't remove the lowest vote getter. All right. So I want to make this clear. If we've got three candidates, for example, for the chair position, all three candidates are on the ballot for any election, any subsequent vote that we have. So we vote once, vote twice. We don't remove anybody. We keep voting, and all three candidates are eligible to receive votes throughout that entire process. For that matter, I want to make this point clear as well, you don't have to be nominated in order to be eligible to have a ballot cast for you. So theoretically, not only do we not remove the lowest vote getter, but you're eligible to vote for anybody on any of those ballots. And so I just want to make that very clear. Thank you for bringing that up, Mark, and I apologize for any confusion. All right, Tom asks, could you answer questions about self-organized counties? What's the difference? Self-organized counties, that's an election under 59.10 of the statutes. And the two areas where this really gives us flexibility as counties is that we get to establish the compensation system for our county board supervisors without following the strict mandates within 59.10 of the statutes. And then we also have the ability to define the process to fill a vacancy on the county board in the event that we have somebody that is the seat becomes vacant midterm. 59.10 contains a process right now for filling that vacancy. If we are self-organized as a county, we get to dictate what that process looks like. To become self-organized, all you're required to do is adopt an ordinance that said we elect self-organization and send a certified copy of that ordinance to the Secretary of State. As I recall, we have 54 or 55 counties that are self-organized. There is no downside to self-organization. You don't have to do a darn thing different once you become self-organized. It simply gives you the flexibility to address what, in my mind, are the two important issues, and that is vacancy and supervisor compensation without following the strict mandate of 59.10. William asked the question, is there anything that prevents attendance at the annual meeting via Zoom or other electronic means? Robert's rules does address electronic meetings, anything on proxy voting for officer elections. There is no authority to do proxy voting. I want to make that clear. You have to be in person to vote. So that's fine. You can attend a meeting by remote communication, but you have to have something in your rules allowing for remote attendance. And you will see that, again, that topic addressed in the template board rules that we put together with WCA. Robert's Rules 12th edition, I don't have it in front of me, but I believe it says that we have to have bylaws or something authorizing remote attendance. Great. So we either allow it or we don't allow it. Fine. If we allow it, let's define the rules about remote attendance. Do we want to have remote attendance at the organizational meeting? I happen to dislike having remote attendance at the organizational meeting, but that's just me. Are we going to allow somebody who is in a meeting by remote communication to participate in a closed session? Yes or no? Those are just a couple of examples of things that we want to make sure we address within our board rules, defining the rules surrounding remote attendance at meetings. Robin asks, is there a new county board supervisor who does not know any of the candidates for chair or vice chair? Can that supervisor ask them to speak on why they should be considered for the opening? Great question, Robin. And that's why, again, I think it would be great if we have the candidates for a particular office address the entire body and give their qualifications and state their desire as to why it is they want to be in leadership for that particular county board. So again, I think we're asking an awful lot of new supervisors to sit in that seat for the first time and be overwhelmed with the education and training materials we're giving them. Let's try to give them the tools that they need to make informed decisions. And one of those tools is getting to know your fellow board members and the candidates for leadership. So I think it's a great idea to have them give a short speech. We can limit it to 5 minutes or whatever you feel is necessary, but ask them to give a short speech about why it is that they want to be board chair or vice chair and the qualifications they possess to lead the group. All right, other questions? Well, if we don't have any other questions, I'm happy to give you 5 minutes of your afternoon back and adjourn early. I will end by saying this. If you have questions about your organizational meeting, feel free to reach out to WCA, reach out to me, and we're happy to talk with you about what your organizational meeting can look like in terms of the legal requirements, whether they be by ordinance, board rule, or statute. Talk to your corporation counsel. We want to make sure that everything that we do at the organizational meeting is consistent with the law. But otherwise, to the extent that WCAI can help with that process, we're happy to do so. As I mentioned, tune in for the March discussion In the Boardroom, where we're going to talk about Chapter 17 processes. And for that matter, if you have any questions just related to county government in general, as we commence a new 2-year term with new supervisors, please lean on WCA, because WCA and me, we're always happy to help county governments out there run their meetings in the most efficient way possible. So thank you all so much for your interest in county government. I wish all of you luck in the upcoming elections. And again, look forward to seeing you next month.